what is this?
T-Series saying cease and desist.
Apparently, not only did PewDiePie get a cease and desist letter from T-Series,
he got sued in a New Delhi High Court over his 2 diss tracks.
Obligatory vlog. Hold on! For those of you who don't know me, I am Viva Frei, a Montreal litigator turned YouTuber. I do these things called vlogs, that's the wrong way, VLAWGS, where we analyze and break down something that's going on in the legal world in terms that can be understood by lawyers and non-lawyers alike. Oh, vlogs, VLAWGS, we break down things for the, people who are not lawyers to understand. The thing with T-Series and PewDiePie, for those of you who don't know, there was a battle between T-Series and PewDiePie over YouTube dominance. Do you know about this battle? They were neck and neck up until about 95 million subscribers, at which point T-Series overtook PewDiePie for the #1 YouTube channel on YouTube. PewDiePie, being the internet comic that he is, released what is known as a diss track, which was called Congratulations, congratulating T-Series on having surpassed PewDiePie as #1 YouTube channel on YouTube. The song went viral to say the least. PewDiePie ended up taking the lead back from T-Series regardless. In the song, PewDiePie talks about having received a cease and desist letter from
T-Series saying cease and desist.
I thought it was a joke.
I thought it was a joke.
What was it for?
It was for his first diss track called Bish Lasagna, B-I-T-C-H Lasagna. Classic song, I mean, it's comedy. Apparently, not only did he get a cease and desist letter, PewDiePie was sued in a New Delhi High Court where T-Series...
Did he have to go to India?
Well, that's what we're going to get into for this vlog. But not only did they sue him, they sought the takedown of the 2 videos internationally. They went in with what appears to be a provisional or interlocutory injunction ordering that the video be taken down off the internet because it was offensive, defamatory, shocking, racist, discriminatory, all sorts of things.
Definitely shocking.
It's definitely inappropriate content. Is it content that should be taken off the internet by way of court orders? I'm not here to give my opinion.
I'm Poppy Gloria.
But the amazing thing is that this illustrates a number of amazing aspects of law as relates to interlocutory injunctions and as relates to being a foreign defendant in another country to a lawsuit instituted by a big money-making corporation in that country, province, state. What do you think? Is it good to be an out-of-state defendant being accused of egregious wrongdoing against a local corporation that everybody loves?
No!
After I dump my wife off at work, I'm gonna go have lunch with DSLR Dave, the man who does my thumbnails. And maybe we should just skip to that moment right now. And this is DSLR Dave. He has his own YouTube channel, full-time job, and he makes thumbnails for various YouTubers. His thumbnails are awesome. Dave, do you want to spend all breakfast talking about PewDiePie and his lawsuit by T-Series?
Sure, go ahead.
No, I thought you were going to say no.
No? Oh, no.
DSLR Dave. I'll put a link to his channel here. They're
Right
amazing.
there.
Here, somewhere here. One of us will be right.
Okay.
So T-Series actually filed a lawsuit against PewDiePie ordering the removal of his 2 diss tracks from the internet. Now we have to read this actual lawsuit in order to really understand what's going on in it because it can teach us a ton. Check this out. In the High Court of Delhi at New Delhi, Super Cassettes Private Limited, I imagine that is T-Series' official business name or alternative business name, versus Felix Arvid Ulf Schellberg and others. Order 0804-2019. This application is filed under Order 39 Rules 1 and 2 CPC seeking ad interim injunction in favor of the plaintiff and against defendants number 1 to 3 from uploading, communicating, or making available the impugned songs, namely T-Series diss track, Bitch Lasagna, and Congratulations, or any other version thereof. Can you imagine that this has actually become the object of a lawsuit? Let's read paragraph 2 and then we're going to go back to what is called the order at the beginning of this suit. The accompanying suit is filed seeking a decree of permanent injunction in favor of the plaintiff and against defendants number 1 to 3 from uploading, communicating, exploiting, etc. the impugned songs as noted above. Other connected reliefs are also sought. So here's what I think is happening. This is being referred to as an order, and it is referring to an accompanying suit in the context of an interim injunction and a permanent injunction. What is an injunction? An injunction is an order of the court enjoining, ordering someone to do or to refrain from doing something. And assuming that injunctive relief is the same in India as it is in Quebec, in the context of injunctions, you have what are called provisional, interlocutory, and permanent injunctions. Now let's open up a big parenthesis here. I am a Quebec lawyer. Nothing in this video constitutes legal advice. If you need an attorney, seek an attorney in your proper jurisdiction. This video is for entertainment purposes only, and some of you might find it relatively educational as well. And if you do, like, share, subscribe, hit the notification bell, hit the thumbs up button, that also helps, and tell your friends, family, help me grow my channel. Okay, back to this. You have three types of injunctions: provisional, interlocutory, and permanent. And as we saw in the first paragraph of this motion, plaintiff is seeking an interim injunction. I presume interim means relatively the same thing as interlocutory, and we're going to get into that. And in paragraph 2, we see that plaintiff is seeking a permanent injunction. So here's how it works as relates to injunctions. Provisional are the most urgent of injunctions. Someone is about to bulldoze your house, and in order to stop them, they need to get a provisional injunction. Just stop doing what you are doing until we can go to court and be heard on the interim or interlocutory injunction. So the provisional, generally speaking, is urgent relief to prevent an irreparable harm so that they can have a hearing on the interim or interlocutory injunction. And basically, an interlocutory injunction is less urgent than a provisional. It's intended to safeguard the rights of the plaintiff during the judicial process. The plaintiff will typically seek an interlocutory injunction to avoid something being done such that the final judgment on the merits becomes useless or without object. Let's take an example where someone who purchased a dog from the breeder is going to euthanize the dog, and the breeder finds out about this and wants to prevent the person from euthanizing their dog. They will get an interlocutory injunction to say, don't euthanize your dog until we get a final judgment on the merits to determine whether or not the defendant can in fact legally euthanize the dog. If they don't get this interlocutory injunction and the defendant euthanizes their dog, they can have an order for damages on the merits if the defendant was not entitled to euthanize the dog. But in the absence of an interlocutory injunction enjoining the defendant not to euthanize the dog until the final judgment can determine whether or not they can, the risk is that a situation would be created whereby the plaintiff cannot be made whole again by the final judgment on the merits. The bottom line of an interim or interlocutory injunction is to avoid a fait accompli that cannot be remedied by final judgment. And then we go to the permanent injunction. And a permanent injunction is just a final judgment ordering what the parties can or cannot do permanently on a going forward basis. In order to get a provisional or interlocutory injunction, you need to satisfy certain criteria, and without getting into the nitty-gritty of it because it would be useless to anybody who's not a practicing attorney, you need to show things like color of right, balance of inconvenience, irreparable harm, things like that. A judge is not going to order an interlocutory injunction if the plaintiff doesn't have any color of right to the remedy being sought at the interlocutory injunction stage. A judge is not going to grant an interlocutory injunction if everything can be remedied by monetary damages on the final judgment on the merits. Hello, doggy. What's up? 1, 2, 3, huh? There we go. Oh, yeah. What do you say? What do you say? You're wet. Why are you wet? Okay, get out of here. So getting back to the T-Series lawsuit against PewDiePie, wherein they are seeking an interim injunction enjoining PewDiePie and others to take down the two songs in the interim until there can be a final judgment to determine whether or not the songs have to come down on a permanent basis. Now, I was not able to find a copy of the lawsuit for the actual interim injunction or for the permanent injunction, but we know that a separate lawsuit was in fact filed accompanying this order because of what is said in paragraph 2. The accompanying suit is filed seeking a decree of permanent injunction. So we know that there is a separate and accompanying suit to this order seeking an interim injunction, a permanent injunction, and other relief. But typically when a party seeks an interim or interlocutory injunction, at the hearing of that interim injunction, they will submit a draft order to the judge, that draft order basically being the order that they want the judge to render. And oftentimes competent and well-prepared lawyers will draft that order and hope that the judge just signs off on it. And that seems to be what happened in this case. We have the order number 0804-2019, and it appears to have been signed off by the judge or the court master. I don't exactly know what that is in the context of the Indian court system, and we have to just quickly read through the rest of it so that we can understand what's being alleged in here and what PewDiePie ultimately decided to do as a result. Paragraph 3 basically describes the rivalry between T-Series and PewDiePie. It is submitted in the accompanying plaint that the defendant number 1 operates a YouTube channel, namely PewDiePie, and has for quite some time been the most subscribed channel on YouTube in the world. Of late, the popularity of plaintiff has increased so significantly in the world market that the plaintiff has recently overtaken defendant number 1 as the most subscribed YouTube channel in the world across all categories. It is pleaded that in a bid to outscore the plaintiff and regain its top position, defendant number 1 has been uploading defamatory and disparaging music videos which target the plaintiff and Indians as a community and contain racist, inflammatory, and hateful remarks against them as well as T-Series in a bid to ridicule and disparage the plaintiff and his trademarks. That is giving PewDiePie's diss tracks a lot of credit. They may be offensive and they may be childish humor, but they are, or at the very least, intended to be humor nonetheless. And humor typically has a disparaging nature to it, otherwise, generally speaking, humor tends not to be funny. Roasts, if they were not disparaging,
Would not be funny.
Now all of this is not not intended to condone the humor in PewDiePie's songs. It is not the type of comedy that I would ever make. It's not the type of song that I would ever make, because I know ultimately, despite the fact that it's intended to be humor, it would in fact insult people, and I am not in the business of trying to insult people. But it is humor nonetheless that is being taken very seriously right now. It is pleaded that the lyrics used in the two impugned songs uploaded by defendant number 1 in conjunction with other defendants number 2 and 3 are on the face of it defamatory, disparaging, insulting, and offensive. These videos are accessible throughout the world to a global audience of more than 1 billion who access internet and YouTube every day. At paragraph 6 it goes on to say how PewDiePie apparently apologized for his first diss track, but then uploaded the congratulations song a little bit later. However, learned senior counsel for the plaintiff points out that recently, on March 31st, 2019, a new video has been uploaded by defendants number 1 to 3, which are on the same line as the earlier videos. And to paragraph 8, we get into the criteria for the courts to grant interim injunctive relief. The plaintiff has made out a prima facie case. Prima facie case meaning that on its face they have a legitimate issue to be tried. Balance of inconvenience is also in favor of the plaintiff. Balance of the inconvenience means who's going to be greater prejudice if the interlocutory or interim injunction is granted. Assuming everything alleged in this motion is true, if the video stays up online until a judgment on the merits might order the video to be taken down, the argument is going to be that the damages caused to the plaintiff are greater than if the video comes down now, and if the judgment on the merits says no, you can have the video back up, all PewDiePie has to do is put it back up at that point, and all he has lost is revenue from that video in the interim. Whereas, the argument would be, if the video stays up until judgment on the merits, you might have a year, 2 years, even more, of offensive and defamatory content that tarnishes T-Series' brand and trademark. Now, it seems that the interim injunction was either granted or consented to, and from videos that PewDiePie subsequently made, it seems that PewDiePie in fact consented to removing the videos from the internet, at least in India.
I made 2 diss tracks that were made in fun, ironic jest. They were not meant to be taken seriously. High Court in India demands that they're gonna be blocked. This was all made to be fun, but it's clearly not fun anymore. And out of respect for that, I'm gonna keep the videos blocked.
Now, in law, I happen to think that PewDiePie is right. While I can understand people finding that song offensive, I don't think there's anything in it remotely defamatory in the legal sense. The statements in the song that are not true are so absurdly not true that they are not intended to be taken seriously. The lyrics that are true in those songs, namely that T-Series' business was started off selling pirated songs, is true. So on the one hand, you have humor and comedy that is patently intended to be humor and comedy, and on the other hand, you have truthful statements that can't constitute defamation. That being said, is PewDiePie consenting to these interim and permanent injunctions a sign of weakness or a sign of strategic intelligence? You've heard me say it time and time again, one can never know how a judge is going to rule on the merits. Leave it in the hands of a judge, you don't know what's going to happen. Leave it in the hands of a judge when you are a foreign defendant to a local plaintiff in the local plaintiff's playground, you are running an even greater risk of not being happy with the final judgment. There's something called home team advantage. There is definitely something called home plaintiff advantage in their own jurisdiction, in courts, with judges that they probably know, with lawyers who know everybody. It's a small world. And when you have a foreign kid from Sweden in a New Delhi court defending lyrics that insult a local company and the local people, justice is human, and you can imagine what a head start T-Series is going to start with. And not just that, everybody says it's a question of principle, you have to fight the good fight, lawyer up and defend yourself. Felix would have to mandate a lawyer in New Delhi to defend Felix in this lawsuit in New Delhi. He would have to travel to New Delhi in order to defend against the lawsuit. Even if he comes out a winner, what's he going to get out of it? It's going to cost him legal fees, inconvenience, and the risks of a negative judgment just so that he can keep a video on YouTube in India? And if PewDiePie doesn't agree to certain conclusions or find some sort of negotiated settlement, what can end up happening is that the plaintiff can get a default judgment against PewDiePie for absence of defending himself in the New Delhi court. If the defendant doesn't appear or get a lawyer or defend themselves to the suit, plaintiff can get a default judgment granting all of the conclusions being sought. Permanent injunction globally, damages, etc., etc. This is one of those situations where, questions of principle aside, a negotiated settlement that basically meets T-Series' immediate needs is obviously the way to go. And ultimately, PewDiePie is just trying to have fun, albeit in a childish way. He's just trying to have fun. He is not after setting legal precedents on a global scale, maybe to the disappointment of some of his followers or some of the rest of the YouTube community that hopes someone is going to set a standard as to what is online defamation, etc., etc. A foreign defendant being sucked into the legal system under these circumstances is certainly risking more than they can afford to lose. And like I always say, one should never gamble with more than one can afford to lose. On that note, now you know your vlog. Peace out. Boom!